Welcome in, everybody. Before we get started, please like, subscribe, and hit the notification bell. You know, all the YouTubey things. Forget what you think you know about justice. Welcome to the Virtual Juror, where snark is reality, but evidence is royalty. Where at first we look at the FACS, or Facts and Conjecture Shared, before we get into the real stuff. If you thought your Google search history was embarrassing, welcome to Day 3 of the Brian Walshe trial, where we learn that how to dispose of a body is apparently not the only incriminating digital footprint one can leave. Today wasn't about the gruesome how-to guides. That was yesterday. Today was about the why, money, and the where, nowhere. The prosecution brought in a parade of record keepers to prove Ana Walshe didn't just vanish into thin air. She vanished into a very specific tragic void, while her husband allegedly made it happen. Outside the presence of the jury, there were 3 issues. First issue, the rug. The defense argued that even though they were not challenging the authenticity of the rug, the image is unduly inflammatory since it shows Ana interacting with her children in the family home on the rug. Because, Your Honor, showing the victim happy with her kids is a desperate ploy to make our client look like a monster. The Commonwealth did not view the image as inflammatory and wished to present it as part of their case, since the burden of proof is theirs. Because, Your Honor, we view this as evidence. We have a right to show the jury, and this is a critical piece of discarded evidence. It's not our fault it's potentially damning. The court said the Commonwealth had the right to present the evidence, but told them the image needed to be edited so that the children were not visible. She gently reminded the defense, again, that proving the elimination of a person usually involves the victim. Because, simmer down, the Commonwealth has the burden and they get to present their case. But we are not running a horror movie here. Crop the adorable children out of the picture. Sorry, defense counsel, Ana gets to stay in. Because the victim gets to be represented in the evidence presented. Second issue, the fast-out text messages. The judge ruled that some of the messages contained relevant state-of-mind evidence, and she noted a conflict. Brian remembers when one of the children went to bed, and that happened to coincide with when a text message was sent. Did he have telescopic vision, or was he receiving her messages? Since the content of the text suggests that Ana wasn't sharing her phone, the reasonable inference is that Brian may have been eavesdropping. Some of these texts are state-of-mind gold. Others are just boring friend talk. Call the boring stuff. Third issue, consciousness of guilt. It's obvious the lawyers are being very careful not to explicitly connect those delightful yet suspicious search terms to Brian Walshe. At least, not yet. They're calling him the user, like a polite IT tech. After all, the defense claimed in opening that Brian lied, so the judge is just waiting for the hammer to drop with an official link that the user is the lying defendant. The court has not given the jury a consciousness of guilt instruction. Yet. But once the link is made, during testimony that Brian made the searches or that he lied to the police, she might just give it sua sponte, or on her own authority. The defense objects to any instruction being given, and they insist on reviewing the exact wording of this potential instruction. They're not admitting guilt, merely explaining a moment of extreme panic, because Brian isn't automatically guilty because he fibbed to a cop, or accidentally typed something incriminating into his computer. Now let's get to today's witnesses, continuing with Commonwealth Witness number 2, Trooper Nicholas Guarino. The gist. Trooper Guarino read some highly incriminating search terms found on Brian's laptop, which included queries about dismemberment, body disposal, decomposition times, and the effectiveness of tools like hacksaws. The timestamps place those searches squarely in the days following Ana's disappearance. Let's recap the prosecution's perspective. Trooper Guarino served as the Grim Reaper of search history, reading into the record a list of queries so incriminating they practically came with their own handcuffs. The Commonwealth wants you to believe that Brian wasn't just surfing the web, but was actually following a step-by-step guide on how to dispose of the evidence while becoming a widower. Guarino highlighted the timestamps, showing that while Ana was supposedly traveling, he was making these searches. Moving to the defense's perspective, attorney Larry Tipton countered this with a little thing called context, suggesting Brian is just a man of diverse intellectual curiosities, like Guarino has never gone down a 3 a.m. Wikipedia rabbit hole. He pointed out that sandwiched between the prosecution's favorite gruesome queries, Brian also searched for Porsches, because his wife wanted one, and diamonds. Hardly the behavior of a man plotting doom, unless he planned to kill her with kindness first. Tipton emphasized the best state for a man to divorce search, arguing that this proves Brian was attempting to protect assets by looking for a legal separation, not a mortal one. Honestly, if researching divorce and disposal methods in the same week is a crime, then indecisiveness is a felony. The defense painted Brian's frantic searching not as an elimination plot, but as the chaotic, anxiety-fueled rabbit hole of a stressed-out husband. After all, haven't we all Googled, "Can you be charged with murder without a body?" at 4 a.m. out of pure, innocent curiosity? We're going to consolidate some witnesses, so that means we'll be taking a few of them out of order. Commonwealth Witness number 3, William Foley, is the keeper of records for U.S. Customs and Border Protection. Commonwealth Witness number 5, Thomas Menino, is corporate security for JetBlue. Commonwealth Witness number 7, Seth Fox, is the subpoena compliance specialist for Lyft Technologies. And Commonwealth Witness number 8, Alyssa Wimmer, is the regional public safety liaison for Uber Technologies. The gist. Brian told police Ana took a rideshare to Logan Airport in Boston for a work emergency in D.C. on New Year's Day. The records determined that was a lie. Here's the prosecution's perspective. She never left the house. The records are brutal. From U.S. Customs' point of view, Mr. Foley took the stand, just in case anyone thought Ana might have pulled a Gone Girl and fled to Europe. She certainly didn't flee the country. Her passports had not been used since a trip to Europe around Thanksgiving 2022 and returning on December 7th, 2022. Her passport was never scanned again. This testimony closed the door on the "maybe she ran away to start a new life as a sheep farmer" theory. From JetBlue, continuing the theme of trips Ana never took, Thomas Menino testified to all of the flights Ana missed. Ana booked flights on November 5th for January 3rd, 13th, 16th, 27th, and 30th, but she was a no-show for all of them. It painted a bleak picture of a woman with future plans that were abruptly canceled, directly conflicting with Brian's narrative that she had flown off to D.C. It turns out it's very hard to board a plane when you're allegedly being dismembered. Finally, we were treated to the Ghost of Ana Walshe travelogue, courtesy of reps Alyssa Wimmer and Seth Fox from Uber and Lyft, respectively. They confirmed that while Ana was allegedly traveling for work, her rideshare apps were gathering digital dust. A Lyft rep testified that she took 0 rides between December 30th and January 8th. And the Uber rep confirmed she took 2 rides on December 30th, and then proceeded to go nowhere fast. This testimony served as a dry, data-driven way of saying she didn't leave the house, people, effectively beginning the dismantling of Brian's story. The takeaway? The work emergency alibi story is in shambles. But there's always the difference perspective, which is crickets. Honestly, there isn't much spin for the data says you're lying. The defense mostly sat back, likely hoping the jury might believe Ana decided to walk to Washington, D.C., or maybe hitchhike. They focused on the fact that she did have future flights booked, perhaps suggesting she intended to leave, but, well, something or someone stopped her. Moving on to Commonwealth Witness number 4, Officer Patrick Reardon, who's a canine handler for the Cohasset Police Department. The gist. Officer Reardon and his canine partner Einstein, a patrol dog trained for tracking and area searches, conducted a search around the Walshe family residence. However, due to the presence of the Walshe family's German Shepherd aggressively barking in the fenced-in area, they were unable to search the entire property, specifically the backyard. Perhaps this was the only successful defensive maneuver that day. But the prosecution's perspective, Officer Reardon tried. He brought his highly trained and certified dog to help find Ana for a 25 to 30 minute search, but there was no scent to be located to attempt to find her. And from the defense's perspective, silence. Nothing to see here. The dog didn't find anything, so we'll just sit back and take this win. Moving on to Commonwealth Witness number 6, Officer Gregory Lowrance of Cohasset Police. The gist. He was the first cop on the scene, detailing the initial missing persons report. From the prosecution's perspective, Officer Lowrance brought us back to the initial missing persons phase. Brian played the part of the concerned but confused husband, claiming Ana left for D.C. early in the morning. He told Officer Lowrance that he hadn't heard from her in days and contacted her employer first. That's odd, right? The Commonwealth is using this to show his cover story was fully formed from day one. This testimony began to highlight the start of Brian's web of lies, juxtaposing his calm demeanor with the absolute chaos the prosecution alleges was happening behind the scenes and in the dumpsters. From the defense's perspective, he was cooperating. The defense highlights that Brian was talking to the police, letting them into his home, and answering questions. However, they ignored the part where he did not call her phone incessantly like a normal panicked spouse. Then came Commonwealth Witness number 9, Officer Michael Kenyon of Swampscott Police Department. The gist. Officer Kenyon was the designated chaperone for alleged elimination evidence, basically driving the most important load of garbage in Massachusetts history. He came to prove that no nefarious trash swap occurred. From the prosecution's perspective, Kenyon's testimony was short, sweet, yet vital. He established the integrity of the evidence from pickup to drop-off, and provided proof that this was the trash, the whole trash, and nothing but the trash. From the defense's perspective, their only counter was to confirm that Kenyon had no first-hand knowledge of whether the trash compactor contained any trash. They're simply doing their job, trying to sow seeds of doubt about what could have been in the trash. Next up was Commonwealth Witness number 10, Sergeant Amy Waterman, who's part of Massachusetts State Police Violent Fugitive Apprehension Team. The gist. Sergeant Waterman went to search the Walshe, D.C. residence. It was found to be the pinnacle of domestic organization, all neat, tidy, and stocked. It was the antithesis of a frantic getaway, proving that Ana didn't just pack a bag and vanish. Instead, the evidence suggested Ana had a separate, orderly life, with clothes in the closet belonging to someone who probably wasn't her housebound husband, since he was restricted to Cohasset. From the prosecution's perspective, the state of the home proves that Ana was coming back. She didn't empty the fridge or pack a suitcase. She was living there. As for Mystery Man's clothing, since Brian wasn't allowed to travel, she appears to have moved on to a more geographically accessible partner, potentially providing Brian with another motive for extreme non-divorce related action. From the defense's perspective, the home was neat and orderly. This was a woman who was organized and professional. Let the jury focus on the documents, the legitimate travel and address paperwork, and ignore the prosecution's flimsy implications about the contents of the closet. The presence of a few shirts does not constitute a motive for elimination. And next was Commonwealth Witness number 11, Peter Capozzoli, otherwise known as the Landlord. The gist. Brian suddenly became interested in property security after his wife went missing. From the prosecution's perspective, Mr. Capozzoli delivered perhaps the most "are you kidding me" moment of the day. He testified that Brian called him in the first week of January, not to ask about rent or a leaky faucet, but to ask a very specific question. Do you have cameras on this building? When the landlord said no and asked why, Brian dropped the "my wife is missing" line. This looks like a suspicious attempt to figure out if his disposal activities had been caught on tape. It's the criminal equivalent of asking a cop, hypothetically, how fast would I have to go to outrun your cruiser? Purely for research purposes, of course. From the defense's perspective, he's a concerned citizen. The defense would like you to believe that Brian was just a worried husband, ensuring the property was safe. Or perhaps he was just a curious guy. They downplayed the timing, suggesting it's normal to ask about security when your wife has disappeared. Then came Commonwealth Witness number 12, Mark Selvaggi. He was a New York Life insurance representative. The gist: apparently Ana Walshe may have been worth more dead than alive, at least on paper. Mr. Selvaggi testified that Ana had a cool $1 million term life policy, plus a $250,000 whole life policy, with, you guessed it, Brian as the sole beneficiary. From the prosecution's perspective, motive, anyone? The Commonwealth is practically drawing a $sign over Brian's head. They emphasized that Brian had no income, and that his federal fraud convictions prevented him from acquiring his own life insurance policy. This made Ana's policy his only potential golden parachute. In a moment of grim irony, Selvaggi noted Ana had an excellent health rating, which is awkward considering the defense's opening theory that she might have just spontaneously died of unexplained causes. From the defense's perspective, it's just good financial planning. The defense attempted to frame this as standard adulting, not a bounty. They contended that eliminating Ana would be financial suicide because she was the primary breadwinner, bringing in the big corporate salary. Why kill the golden goose for a one-time payout when she lays the golden eggs every 2 weeks? Plus, they argued that health ratings aren't medical exams, so maybe she wasn't as healthy as she looked? A weak pivot, but they're working with what they have. The cross-examination pointed out that Brian had referred friends to Selvaggi and attempted to turn him into a character witness as a way to humanize Brian. They implied he wasn't plotting an elimination scheme, but was genuinely interested in insurance for everyone. The prosecution objected, presumably because he was a good referral source, is not a valid legal defense for murder. Today's final witness was Commonwealth Witness number 13, Davis Gould, who was a forensic scientist with the Matthews State Police Crime Lab. The gist: delivering arguably the most damning and graphically detailed to date testimony covering 2 scenes, the Walshes' Volkswagen Taos and the trash found in the dumpster at Brian's mother's apartment complex. His job was to confirm the presence of presumptive evidence and establish the chain of custody. Gould's testimony confirmed 2 things. 1, tiny presumptive bloodstains in the family car. And 2, a massive, undeniable, expertly logged pile of evidence that suggests Brian Walshe bought a "How to Disappear Your Wife" subscription box. His role was to tell the jury, yes, all this terrifying stuff was indeed where we found it. From the prosecution's perspective, this testimony is the physical manifestation of the Google searches. The 10 bags of trash are not just garbage, ladies and gentlemen. They're an eliminator's discarded tools, and the victim's personal effects. The car evidence suggests Ana may have been moved in it, while the 10 bags of trash filled with Ana's belongings and cleaning agents, this establishes corpus delicti, the body of the crime, and it's not a coincidence. It's evidence of a failed cleanup. From the defense's perspective, we're talking about presumptive tests. The defense crossed on minuscule stains and cross-contamination. They argued that the way items were handled, placed directly on a damp floor at the facility and then moved onto bench paper, means the evidence trail might be tainted. Therefore, any biological evidence found could have transferred from item to item like a terrible case of forensic hot potato. They're trying to shift the focus from what was found to was it properly handled? Mr. Gould is a scientist, but he can only confirm presence, not how the contamination arrived. That's doubt, 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 according to the defense. We finished the day with a couple more issues outside the presence of the jury. The first issue: can the jury know about Brian pleading guilty to 2 charges before this trial started? Judge Frenier questioned the prosecution's motive in making this motion to introduce Brian's previous guilty pleas relating to lying to the police and disinterment of Ana's remains, basically saying, "Why are you trying to hit a home run with a foul ball?" She's skeptical, to say the least. She's worried that once the jury knows Brian is a proven, confessed liar, they won't be able to judge the current elimination charge fairly, no matter how strongly she tells them to ignore it. The Commonwealth may want to prove a pattern of deception. However, since they already know about the federal convictions, we're pretty sure that ship has already docked in the minds of the jury. During all of this, the defense was probably silently thanking the judge for her skepticism, because, after all, the jury should focus on reasonable doubt, not dwell on the fact that Brian is already a felonious fibber. The next issue went back to the Fastow text messages. The judge returned to this question late in the day. She seemed to be prepared to admit some of the messages. The defense is playing a high-stakes game of legal chicken. They assume, probably rightly, that the prosecution is going to cherry-pick the most dramatic, unhappy texts. Since the defense can't stop the messages from coming in, they demand the entire digital scroll be entered. They clearly say this is a defense strategy for their client. Only time will tell if this is a good or bad play. Well, that's all we have. So as always, love your family, love your pets, love your neighbors, and we'll see you next time.